Thank you very much, and a very, very warm welcome to you all. It was a huge honour, as you can imagine, when Richard, Lord Wilson, decided to dedicate this series of lectures to me. He, as you know, is a very special person whom I love very much, and this is a moment for me to say thank you to Richard. So please join me. There are going to be 5 lectures, and this is number 3. The first was given by Professor Robert McFarlane, who is here, and the second by Madeleine Bunting, the author. Now, when we started, I said there wasn't going to be a theme, but actually, I think there is a theme emerging, and if there is a theme, it's about how, as a society, we're adjusting to the contemporary world and its challenges, or not, as the case may be. Rob McFarlane spoke about Is a River Alive, which you're going to hear much more about with his forthcoming book, talking about environmental rights, human responsibilities, and inanimate integrity. Madeleine talked about place and meaning and the social, economic and environmental forces affecting people and place and the vast inequalities which are arising from the way that our society is now functioning. So now to Philippe, Professor Philippe Sands, and his lecture, From Genocide to Ecocide, and I'm confident we're in for an extraordinary evening. Now, if there's another theme, it's that these people are all friends of mine, and I've been calling in favours for the past 3 years, so watch out if for the next 2 I've yet to find the lecturers. And it's a huge favour to have Philippe here, a huge honour to have Philippe here, because he must be one of the busiest people on the planet. He knows and loves Cambridge. He read law at Corpus and was a research fellow at CATS. But we met in 1988 at the Hinkley Point C public inquiry, the nuclear power station inquiry. And actually, there's a little irony here because Richard had only just finished working with the Department of Energy, I think, at that time, so he knew at least as much about nuclear power as anybody. I was running CPRE's case, which was a largely economic case, showing that the expected overrun on costs was something to take into account, which I think we were proved rather right on. So Philippe was, in his legal capacity, was also there. It was an incredible, exciting time, because I was also running CPRE's case on the electricity privatisation bill, which was going through Parliament, lobbying a young Tony Blair, who was the shadow energy spokesman. It shows how old we all are, I think. At one point, actually, I was handed the proverbial brown envelope, and then a few weeks later, nuclear was pulled from the privatisation. So, of course, I have no idea if the two events were connected, but it was an exciting and interesting time. Anyway, our paths sort of diverged, and you'll hear more about what Philippe has been doing. And Philippe has become, frankly, among the most respected academic international lawyers in the country, as well as being a practising barrister and involved in an enormous number of courts and international tribunals. He's currently Professor of Public Understanding of Law at UCL and visiting Professor at Harvard. And his practice with 11 King's Bench Walk has taken him all over the world. But he's much, much more than that. He's a pioneer of environmental litigation, working on maritime exploitation and boundaries, pollution, whaling, climate change, to name but a few. He's even better known for his focus on the illegality of war, especially in relation to Iraq and Syria, torture in relation to Guantanamo Bay, and of course human rights, for which he's famous globally. And perhaps even better now for his work on genocide, where his amazing book, East-West Street, he calls it literary non-fiction, I think, rather than simply non-fiction, which is a rather lovely description, based on his own family's experience, catalysed huge interest in the origins of genocide and crimes against humanity. And his 2 further books, The Rat Line and The Last Colony, about tribals, were also brilliantly reviewed. Philippe literally never stands still. Among many philanthropic roles, he's on the board at the Haste Festival, where he's currently caught up with the evidence, or lack of it, in relation to the cessation of Baillie Gifford's sponsorship of the festival, so never not involved in these discussions. And of course his work on Ecocide, which is gathering momentum, and which we are fortunate to be hearing more about this evening. Philippe, welcome.
Thank you, Master, and thank you, Fiona, for the introduction. It is, I'm here for personal reasons. It's when Fiona Reynolds calls, you run. She is a very, very special person. Sir Richard, I think you're aware of that. We go back now, amazingly, it seems incredible, nearly 40 years, although I was astonished when you told me earlier this afternoon that you were 28 years old when I met you, because she seemed so important and famous. And when we asked her to join the board of an organization we created, my friend James Cameron and I, in 1988, the Centre for International Environmental Law, she was the director of Council for the Protection of Rural England. And the thing you need to understand is the patron was Her Majesty the Queen. And so at that point in life, it was sort of unimaginable to us that someone who was connected to an organization on which Her Majesty the Queen was the patron would have anything to do with us. But we wrote to her after Hinckley, and it's been an amazing journey ever since. And you've been a real source of inspiration. You're an incredible person, Fiona, and it's a real privilege to be here. I've learned so much from you. One clarification, I would never call my writings literary non-fiction. That is a Ponzi German thing. My German publisher, Fischer, who are fantastic, put it in their category of literary non-fiction. So I'm stuck with that nomenclature, but I sort of quite like it, actually. And it seems a little plus. And tonight, I want to sort of take you on a bit of a journey, and it will meander in different directions, but I think you'll work out what it is that I'm trying to say and talk about, bringing disparate topics. I originally thought what I really could talk about tonight was genocide and crimes against humanity, which is very much in the news right now, and I will be touching on current affairs, I hope, sensitively and delicately. But I felt, with our background, Fiona, and starting on international environment, I had to connect it to our way of coming together all that time ago, and so I'll make that linkage. But bear with me as I tell you the story, as we work our way in that direction. So, in a nutshell, so you understand, I became very involved in environmental issues at a very early stage in my career, completely accidentally. I was here in Cambridge on the 26th of April, 1986, when the accident happened, as we now know, it was denied at the time, at a place called Chernobyl in Ukraine. And a few weeks after the accident, I was invited to give a paper in Washington, D.C., to a place to which I'd never been, on the legal aspects of Chernobyl, essentially transboundary pollution, which of course was not an issue in international law at that time. I knew nothing about it. It's not a critique of Cambridge University, but the word environment did not feature even once in 4 years of studying law at Cambridge University between 1979 and 1983. I think that would be the same across the whole of the United Kingdom and much of Europe, although probably not Germany and Austria, but in England anyway, it wasn't part of our consciousness. So I literally knew nothing. I knew a little bit about international law. And Elie Lauterpacht, who was my mentor and took me under his wing and got me really a first research fellowship at St. Catherine's, which I loved, said, no, you must go and do it. It doesn't matter that you don't know anything about it. Welcome to the world of international law. We just muddle by and you'll work it out. But I got very immersed in it. And one thing led to another in terms of the direction of work that I took. And from that paper on Chernobyl came the work at Hinkley Point, working as a very young barrister for Greenpeace. And from that, I then got involved in the negotiations of the Framework Convention on Climate Change. I was just describing to Fiona the incredible experience in September 1990 of hearing Margaret Thatcher at the Second World Climate Conference, I was in the room, lecture on climate change, an extraordinary lecture that she gave. And that was the moment that catalyzed, literally, her speech, because most other leaders were skeptical. The Framework Convention on Climate Change is sort of been forgotten in history, but I was in the room and it really did happen because she knew what she was talking about. She was a scientist, she was a chemist, she understood what was happening. And so I got involved in climate change, and then from that, I got involved in the cases at the International Court of Justice on the legality of the use or illegality of the use of nuclear weapons. And then the Pacific Island states with which I was working on that case said, there is this thing in Rome in the summer of 1998, the negotiations of a statute for an international criminal court. Would you go along and be our legal advisor? And I became involved for the first time in international criminal law. I'm not a criminal lawyer. And so it's a way of explaining that the way in which we get involved in things is slightly accidental, but the environment was the beating heart. And Chernobyl was the really start of it. And from the statute of the International Criminal Court, I then became very involved in international criminal law, and most, if not all, of the cases on crimes against humanity and genocide at the International Court of Justice in relation to Rwanda, in relation to Yugoslavia, and so on and so forth, I got involved in. Very painful stories to be involved in, very brutal and awful stories, but also, in a certain sense, a privilege to be present at the moment when international criminal law came alive, 50 years after Nuremberg, because nothing happened between 1945 and 1995, as many of you know, substantively in these areas. So by 2010, I am very immersed in international criminal law, although I still would not presume to call myself a criminal lawyer any more than I would presume to call myself a writer of literary non-fiction. And out of the blue, I receive an invitation from an obscure place that I've not heard of, Lviv, in Ukraine, the law faculty. And I work out pretty quickly on Google that Lviv is, that's the Ukrainian name, in Russian it's Lvov, in Polish it's Lvov, in German it's Lemberg. And the moment I hear Lemberg, I'm really interested because I knew that was the place where my grandfather was born. And they have invited me to come and give a lecture on the work and the cases that I do on crimes against humanity and genocide. And I accept not because I want to give a lecture on crimes against humanity and genocide, but because I want to find the house where my grandfather was born in that city. That's why I went to Lviv, accompanied by my mother, my aunt to protect me from my mother, and our 15-year-old son at the time to protect me from my aunt. And we toddled off and we found the house, a place that my grandfather never talked about. He left, he was born in 1904, he left in 1914 when, ironically enough, given what's going on now, the Russians occupied Lviv, and he went off to Vienna and never once would talk about what happened in that period, or indeed in Vienna. So the trip to Lviv was a way of uncovering matters of identity, to know who my grandfather was, which was really a way of knowing better who I am, because you need to understand where you come from to have a better sense of yourself. So I accept to give this lecture. And I spend part of the summer preparing the lecture that I'm going to give at the University of Lviv in Ukraine on crimes against humanity and genocide. And I stumble across some curious things. The first thing I discover is that the man who put the words crimes against humanity into the Nuremberg Statute that was adopted in August 1945 was Hirsch Lauterpacht, who happened to be the father of my mentor, but even more remarkably, went to university in Lviv and was a student at the law faculty in Lviv from 1915 to 1919, and no one in Lviv knew that. So I thought, well, that's really interesting. I'm going to turn up in Lviv and tell them that the man who put crimes against humanity into international law not only came from the region, not only came from the city, but from this very law school. So I thought that's going to be good. And I carry on doing my research. And then I discover that the man who invented the word genocide, published for the first time in a book in November 1944, Raphael Lemkin, you couldn't invent it, studied at the University of Lviv. From 1921 to 1926, he did not overlap with Lauterpacht. In fact, remarkably, the two men never met, which is extraordinary. And so I turn up in Lviv in October 2010 with this, lecture that it actually all began in this city with these two characters who shared a conception of the idea that new rules of international law could protect the human being. And they differed, however, on the characterization and definition of the rules of international law that could be embraced to protect the human. Lauterpacht's idea, and he's the founder, really, of modern human rights law. This book, International Bill of Rights of Man, published in June 1945 by Columbia University Press, really is the starting point for any modern analysis of law in the international domain on human rights. And his essential thesis is that the individual is the beating heart of the international legal order. And the international legal order's essential function is to protect the individual human being from wrongdoing by the state. And that was articulated in his work on human rights, but also on the definition of the concept of crimes against humanity, which essentially is about protecting individual human beings from harm and from abuse. The essential thesis is that every human being, because they are a living, sentient human being, has rights under international law, irrespective of their gender, orientation, color, religion, whatever. It is the essence of what each of us in this room has because we are human, as individuals. Lemkin's idea on genocide is different. Lemkin's idea is that human beings don't get targeted and abused and harmed and killed and tortured and disappeared because of anything they've done. They get mistreated because they happen to be a member of a group that is hated at a particular moment in time and place. And so if you want to protect the human being, focus not on the individual, but focus on the group. And genocide, in contradistinction to crimes against humanity, which focuses on the individual, is about protecting groups. They both share the ideal of protecting humans, but the path to getting there is different. You've understood it straight away. And the moment you've understood it, you'll look at all of these debates about crimes against humanity and genocide now in completely different ways. And one of the things that emerged subsequently when I wrote up this book into East-West Street, which is now, I think, translated into 31 languages, I never expected that, is because this is a universal theme. It doesn't matter whether you're in Belfast, Bangladesh, Mexico City, Myanmar, everyone understands the relationship between the individual and the group. Every one of you in the room knows exactly what I'm talking about. Why? Who am I? How do I define myself? And how do I want the law to protect me? Do I want it to protect me because I'm a human being, as an individual, or do I want it to protect me because I'm a member of a protected group, or all of the above? You've understood straight away. So that moment in 1945 is absolutely crucial. It is a revolutionary moment. Different paths, but the basic idea is the rights under international law protect human beings as an individual or as a member of a group. They're non-derogable, they apply to everyone, and they are guaranteed by international law. This gets adopted through various conventions, through various instruments. These ideas have not existed since time immemorial. People forget how revolutionary is this 1945 moment. And it's under threat right now, which is why this is a particularly significant moment. Those two crimes get incorporated into the Nuremberg Statute. They get litigated along with the two other international crimes. War crimes, conducting warfare in means that don't distinguish between combatants and non-combatants, civilians and non-civilians, and what is today called the crime of aggression, waging a manifestly illegal war. Those are the four international crimes. And they still exist today as the four international crimes. You will note there is a gap, because in 1945, no one was thinking about the environment. So none of these international crimes are concerned with the protection of the environment. They are wholly, exclusively, and totally anthropocentric. They are about protecting the human, which was how things were in 1945. These norms get then taken forward, the Universal Declaration of Human Rights, 1948, the Convention on the Prevention and Punishment of Genocide, 1948. But for 40 or 50 years, really nothing much happens. There aren't any cases, there aren't any other courts, and there are debates. I remember when I was studying in 1980 international law for the first time with Sir Robert Jennings, he basically didn't talk about human rights, but he certainly didn't talk about crimes against humanity and genocide because it just was not alive as a subject, nor did anyone talk about the environment. And then things began to change in the mid-1990s. There were two catalysts: the collapse of the former Yugoslavia and the terrible crimes that occurred there, and the mass killing in Rwanda. And this happened to coincide with a moment in which the Cold War, for a short period anyway, disappeared, and the Security Council of the United Nations, for the first time, could act by consensus. And it created two international criminal tribunals, one for Yugoslavia, one for Rwanda, and all of a sudden, war crimes, crimes against humanity, and genocide were back, put into the statutes of these two institutions, and they were up and running. And cases were brought. There had not been a case under the 1948 Genocide Convention until 1992, 1993, when Bosnia and Herzegovina brought a case against what is today called Serbia. It was then Serbia and Montenegro, but Montenegro went apart. Now, that case at the International Court of Justice ended up with a finding that confirmed that what had happened at Srebrenica was a genocide within the meaning of the statute of the International Criminal Tribunal for Yugoslavia and the 1948 Convention. But the International Court of Justice did not find that Serbia was responsible for a genocide. And to this day, no state has been found by the International Court of Justice to have been responsible for perpetrating a genocide. What the International Court of Justice did find in the Bosnia versus Serbia case was that Serbia had failed to prevent others, paramilitaries, from perpetrating a genocide. Essentially, the International Court of Justice paused and did not want to put on the forehead of Serbia forever the label of genocidal state. They had, I think, everything they needed to do that if they wished, but as judges, and you can form your own view as to whether that was wise or not, they decided not to do that. There have been subsequent cases, but I'm involved in some of them, Gambia against Myanmar in relation to the Rohingya, which is going on right now, and I'll come in a moment to South Africa. and Israel, but no state has been found responsible for a genocide. Now, the other thing that you need to understand to make sense of what's going on right now is that in 1948, states, in their wisdom, adopted a convention on the prevention and punishment of genocide, which gave the International Court of Justice jurisdiction over the crime of genocide. One state can go to court and allege that another state is perpetrating a genocide or has failed to prevent a genocide. There is no equivalent convention for crimes against humanity. One is being negotiated right now at the UN, nor is there an equivalent convention that provides for the jurisdiction of the International Court of Justice on war crimes. There are Geneva Conventions and there are protocols, but they do not give the International Court of Justice jurisdiction to determine whether war crimes are happening. So this is a very curious and lopsided legal order. And the upshot of that is that if something really nasty is happening anywhere in the world, and you want to get it to the International Court of Justice of this kind of crime, you can't allege war crimes, you can't allege crimes against humanity, you've got to allege genocide. You've understood what is happening. South Africa, to get its case to the International Court of Justice, had to call it a genocide. And this gives rise to some of the issues that I'll turn to now. So, South Africa files its case alleging genocide. Now, the definition of genocide in the Genocide Convention is very particular. And unlike war crimes and crimes against humanity, you have to prove what's come to be known as a special intent. The intent to destroy a group in whole or in part. If 10,000 people get killed on the battlefield, targeted as civilians, chances are it's going to be a war crime. You don't have to prove that the perpetrators intended to kill them as civilians. That's also likely to be characterized as a crime against humanity if it's systematic and on that kind of a scale. You don't have to prove a special intent. But with genocide, in the definition of the convention, is a special intent. And the heart of the issue that you ought to be focusing on what's going on right now, and it becomes relevant, as you'll see when we get a little later to Ecocide, is the place and the meaning of this special intent. So South Africa goes off to the International Court of Justice, brings a case against Israel, and there have been a series of orders that have been given. The first one was the 26th of January, 2024. The court really doesn't say very much. The court basically reminds the parties not to commit genocide. There are challenges for the judges, because in the context of a conflict between Israel and Hamas, or Israel and Palestine, depending on how you want to characterize it, only one of those parties is before the court. When South Africa brings a case against Israel, Palestine isn't before the court and Hamas isn't before the court. And what that means in practice is the court can't say anything about what Hamas may or may not have done. Nothing. You can't address it. You don't have jurisdiction over that issue. So if you're a judge, imagine you see what's going on, you see what happened on October the 7th, and that's excluded. All you can deal with is what's gone on subsequently in relation to Gaza. And if you're a judge, that's a very uncomfortable situation to be in, because you're only being asked to address a part of the story. It may not in the end change your characterization of it, but it informs how you're going to approach the issues. So I want to direct you, when the court gives a provisional measures order, which is legally binding, the judges can append what are called separate opinions or declarations, and those are really worth reading. And I have to say, the reporting in the press, it's not a critique, but it's a reality, has not focused on nuance and the detail. And I'm not going to give you my own opinions, I'm just going to give you the raw material so you can work out for yourselves what you think is actually happening. So, Georg Nolte, the German judge at the International Court, very fine international lawyer, very balanced person, has written declarations in each of the orders that have been given. And he writes in January 2024, bearing these considerations in mind that he set out, I'm not persuaded that South Africa has plausibly shown that the military operation undertaken by Israel as such is being pursued with genocidal intent. Even though I do not find it plausible that the military operation is conducted with genocidal intent, I voted in favour of the measures indicated by the court. To indicate those measures, it is not necessary for the court to find that the military operation as such implicates plausible rights of Palestinians in the Gaza Strip. My decision to vote in favour of the measures indicated rests on the plausible claim by South Africa that certain statements by Israeli state officials, including its military, give rise to a real and imminent risk of irreparable prejudice to the rights of Palestinians. At the present stage of the proceedings, it's not necessary to determine whether such statements should be characterized as incitement to commit genocide. The point that I'm making is, it's quite wrong, reading the court's order and the separate declarations, to conclude that the court has determined either that a genocide has taken place, or even that there is prima facie evidence that a genocide is taking place. Different judges voted for this in different ways. And imagine you are a judge in such circumstances. You don't know how this is going to pan out over the coming months and years. You will be precautionary, you will want to take care, you will not want to get egg on your face. But of course this was reported in much of the media as International Court of Justice finds plausible case of genocide. That's not what the court ruled in January 2024. And indeed, the then President of the Court, Joan Donoghue, has made a public statement. You can watch it on Hard Talk, where she explains what she thought she was doing. Question as to whether judges should be taken to the media in this way, but that's a personal thing. It's certainly not a criticism from me. The point that I'm making is you've got to read the nuance and the detail. Let's fast forward 3 more provisional measures orders to the most recent one, which is May the 24th, so just 10 days ago. Reported as being an order by the court that Israel must stop its entire military operation in Rafah. And the question that one has to ask, is that what the court actually did? Now pause for a moment here, again on special intent, and it's in the Nolte Declaration. And I know this to my bitter cost, having argued, for example, the case of Croatia versus Serbia at the International Court of Justice. The court adopted its approach to special intent that it applied in the Bosnia case, and basically said, and I'm paraphrasing, to prove the intent to destroy a group in whole or in part, you essentially have to prove that that is the only intent, that a reasonable inference could be drawn from. And the difficulty that the court finds itself in the current situation, of course, is that Israel, in exercise of its right of self-defense, no doubt, in my view, excessively and in violation of the laws of the Geneva Conventions prohibiting war crimes and probably also crimes against humanity, is pursuing excessively, perhaps, certainly, exercise of the right of self-defense. In other words, its sole intent, if that intent exists at all, exists alongside another intent, which is to protect itself from armed attacks, to release hostages, and so on and so forth. And so the judges, stuck with their rulings of the 1990s and the 2000s on this only reasonable inference intent, are in difficulty. And they're going to be in difficulty in any case in which genocide is being alleged in the context of an armed conflict, which is what's happening now. Because we all know from human psychology, each of you know, that the idea that we have a single intent when we do something is not how life is. I know from my own life that when I have an intention, it's coupled often with other intentions. And this standard adopted by the International Court of Justice is almost impossible to meet. The reason they've adopted that standard, in part, is they don't want the floodgates to open. If they lower the threshold back to what Lemkin wanted it, back in 1944 when he came up with his definition of genocide, they fear they're going to be, every time there's an armed conflict, every time there's a use of force, the Ukrainians consider that what Russia is doing to them is a genocide. My friends in Ukraine are unhappy that I won't say it's a genocide, because there is a gap between public conceptions of what genocide is and this very high threshold in legal terms of what genocide is. So what did the court say last week, a couple of weeks ago? By 13 votes to 2, the court ordered Israel, I'm going to read it very, very carefully, to immediately halt its military offensive, and any other action in the Rafah governorate, which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. So there are two interpretations. One interpretation, which the media has run with, is this is an order to stop everything in Rafah. The other interpretation is no, it's not. It's only to stop those things in Rafah which could bring about the physical destruction in whole or in part of the Palestinian group. And there is a world of difference between the two. And again, the media, it's not a critique, has not dug deep into the nuances. And you get a sense of that, again, from Georg Nolte's declaration in this case. I considered it justified that the court specified that the orders indicated earlier limit the current military offensive in Rafah as far as it could endanger the rights of the Palestinian people under the Genocide Convention, notably their access to basic humanitarian needs. The court's order, he writes, does not address military operations outside Rafah, and the measure obliging Israel to halt the current military offensive in Rafah is conditioned by the need to prevent conditions of life that could bring about the physical destruction in whole or in part of the Palestinian group in Gaza. And he goes on, thus, this measure does not concern other actions of Israel which do not give rise to such a risk. So you've understood, because you're all smart people, that it's the detail and the nuance that is so crucial. Treat with skepticism media reports that tell you this is what they decided or that's what they decided. I'm not suggesting you all go off and read all these orders and so on and so forth, but the detail is incredibly important. Now, it is not, and I know the judges at the International Court, many of them, that they are not horrified by what happened on the 7th of October, over which they have no jurisdiction, or that they are not horrified by what's happening in Gaza today. But their jurisdiction is limited. They only have jurisdiction in relation to genocide. They have no jurisdiction on war crimes. They have no jurisdiction on crimes against humanity. They have no jurisdiction on the illegality of the use of force. And so as judges, their role is to interpret and apply the law, not to legislate, not to go beyond the limits of what states have told them they can do. And they are in a hugely difficult context. So let's break from that to ecocide. One of the concerns I have had, for those of you who've read East-West Street, you will understand, because I touch on the debate between Lauterpacht and Lemkin on the relationship between genocide and crimes against humanity. Lauterpacht was totally against the concept of genocide, completely, for the rest of his life, because he believed that the crime of genocide as articulated by Lemkin and as developed in the 1948 Convention would replace the tyranny of the state with the tyranny of groups. And it would reinforce the special place of the group in our society. He didn't articulate what I'm about to say next, but I think if he had followed through the logic of what's happened subsequently, he would, I think, probably come to the same conclusion that I've come to, which is to express the concern that the very invention of the concept of genocide has given rise to the conditions it was intended to prevent. Until the Genocide Convention, the reification of the group in the international legal order did not exist. This was the moment that it came into being. And from my own experience in litigating cases on genocide, I've come to understand the passions and the deep psychological effects of alleging genocide, or it being alleged that you as a group are responsible for a genocide. It inflames passions like no other. Genocide is seen, wrongly in my view, by members of the public as the crime of crimes. It's not. It's not on a pedestal above war crimes and crimes against humanity. They're all on a level playing field. I think the reason it's come to be seen as the crime of crimes is that, firstly, the word has a magical quality to it. War crimes, crimes against humanity, technical, legalistic, whereas genocide, Latin and Greek melded, brilliant invention by Lemkin, evokes horror in a way that the two other terms do not. And secondly, I think that the evocation of wrongdoing to a group inspires in many people a feeling of particular horror. And you'll have, if you've read East-West Street, you'll have seen that much of the book is my own struggle on whether I'm with Lauterpacht or Lemkin, and intellectually I'm with Lauterpacht, until the last page of the book, when I go to a mass grave outside the small town of Zhulkiev, just close to Lviv, and I'm presented by an unmarked mass grave, 3,500 people, including, still there today, the families of Hirsch and Eli Lauterpacht and my grandfather's family. And even just talking about it, it inspires in you a feeling of kinship and connection that is just somehow different. You understand that I'm a member of that group. If I had been there at that point, I would be there today. You are connected. And I think what Lemkin's magic was to understand this sense that so many, if not all of us, have of connection and kinship with groups. And what prosecutors at international courts will tell you is that when these horrors happen, they are deluged by the victims who want the crime that has been perpetrated to be characterized as genocide. It's not enough if it's crimes against humanity or war crimes. It inflames passions. And it inflames passions on all sides. In the current situation, Israel, Hamas, the allegation of genocide is a rallying call, and on the Israeli side, it is particularly offensive in ways that the other crimes don't have those consequences. So, coming back to the point that I was making about the consequences of the need to prove the special intent. So I've been in rooms with a president of a country, a prime minister of a country, where you're debating the effort to prove that a genocide has been perpetrated against your community. And what I notice in that particular context is that the need to prove that special intent has a double reinforcing effect. It reinforces the sense of the victim group as victims, and that makes them mad and angry, mad in the American sense. And it reinforces the sense of hatred of the perpetrator group. And that doesn't happen with crimes against humanity and war crimes. It is particular to genocide. Anyone who's worked on genocide knows exactly what I'm talking about. It is prone to inflame psychological passions in a way I've come to believe is unhelpful. There's not going to be much we can do about it. The word is out there, it exists, it's all going to be about how courts and judges interpret and apply it in the future period. But that's the context in which I want to say a bit about ecocide. So, as I said at the beginning, in 1945, no one was thinking about the environment. So when they basically invented their list of 4 international crimes, no one thought, oh well, let's include massive damage to the environment as a 5th international crime, because, you know, it's fine, the environment's fine. But it turns out, of course, the environment isn't fine. Environmental consciousness at the international level in legal terms only began to emerge in 1972 at the famous UN Stockholm Conference on the Human Environment. When I studied in the 80s, there was no environment, and I remember still having debates with Ian Brownlee in the 1990s and asking him, why don't you put a chapter on the protection of the environment in your famous book, Principles of Public International Law? And he would just look me straight in the face and say, because there's no such thing. International law doesn't protect the environment. Until the International Court of Justice says the protection of the environment is part of international law, I'm not going to put it in my book. Well, that finally happened in 1996, and then he put in a sort of teeny little... I mean, it's generational. Many of you will understand what I'm saying. The environment is a generational thing. So consciousness has begun to change. There are now a whole raft of conventions on the protection of the environment under international law, and increasingly there is a move to criminalize at the international level widespread, systematic, terrible harm to the environment, and to move away from an anthropocentric approach to the functioning of international criminal law, and to protect the environment not as a means to protect the human, but as an end in itself, almost as the bearer and holder of its own interests and rights. That's what I mean by an ecocentric approach. And there is a move in that direction. At the 1972 Stockholm Conference, which was held in Stockholm, which is in Sweden, the Swedish Prime Minister at the time, Olof Palme, actually talks about ecocide, and it is a term that emerged in the late 1960s in the context of Vietnam, Agent Orange, in the work of various sociologists, and has slowly taken on a life of its own. And one has to credit, I think, in particular, an English barrister called Polly Higgins, who, starting in the late 90s, began to really focus on adding a 5th international crime to the 4 that you are now all expert in. And that move is definitely going forward. And in 2020, everything is connected. Because I had done this work on the environment and have written textbooks on international environmental law and have done work on crimes against humanity and genocide and war crimes, I was asked to co-chair with a very distinguished Senegalese jurist a working group of 12 people to come up with a definition of ecocide that could serve as the basis for an amendment of the Rome Statute of the International Criminal Court to add a 5th international crime to protect the environment. Now, what was interesting, I mean, it was a fascinating experience working on that. It was a very diverse group, you know, across the political spectrum, gender balanced in all ways, and people from all over the world, the 12 of us. It was a very, very interesting group, and there was a real desire of all of us to proceed on the basis of consensus and not have a division, because we've all understood in life that if you can be consensual, it's more likely as an idea to have legs and to go further. But immediately we started working, and it was reported in the press. It was fascinating to me. It comes back to the generational issue, the communications one received, and in particular, the communications from young people who are said to be cynical and not interested in these kinds of things. It's totally not true. Totally, totally not true. I think I'm lucky in the work that I do, and I do lots of interesting stuff. I think it's interesting, and I'm fascinated by what I do, and so on and so forth. But the only time our 3 children have sent me a WhatsApp on the same day was the day, they're all in their 20s, was the day The Guardian reported this working group to define a new international crime of ecocide, and all three of them separately, without consulting, wrote and said, "Oh, Dad, you're finally doing something useful." and I thought that was interesting. And ever since we've done the work, there have been dozens of sort of Zooms and meetings, and it is driven by young people. It is totally generational. And for me, that's really exciting, because if we have somehow stumbled on an area that gets people interested, worked up, energetic, and passionate, that is a really, really good thing. So the definition that we came up with, which is not a perfect definition, it's just a starting point for what is going to come, and it will happen. There will be, in due course, an amendment to the Rome Statute, I have no doubt. And it'll be a variation, obviously won't be the same as what we've come up with, but just to give you a sense of the definition that we've come up with, and then to tease out some of the issues, and then to hook it back to the discussion on genocide. For the purposes of this statute, this was our consensual definition, and it's a very broad group of characters, so I feel very proud that we all agreed on a single definition. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. The crucial point for the purpose of our conversation this evening is we have not included an intentionality element. Pause for a moment. So the main NGO that is involved in this is a wonderful group of people who run something called Stop Ecocide. If you're interested in this and you want to sign up, that's the one to go to. They're really smart, hard-working, serious, interested, and do things really properly. And I came into the project because I have a certain skepticism of the genocide word, for reasons you now know. Why do you have to call it ecocide? Why can't... Because that's going to inscribe it into all the logic and all the problems of genocide. Why can't you come up with something else? Environmental crime against humanity, or why do you have to give it that label? And they said, well, there's a reason for that. We've done some market research. So we went and did some opinion polls, and we went and talked to people in the street and interviewed them and asked them questions and so on and so forth. And we gave them various notions. And if we talked about environmental crimes or environmental crimes against humanity, people said, well, what's that? Just switched off. When they said ecocide, everyone said, no, we're totally opposed to that. That's terrible. That's disgusting. So there's immediately a brand recognition that is connected to the genocide word. And to sort of wrap up where this heads, at some point, states will have to decide whether to run with the idea of ecocide and amend the Rome Statute. Some states, about 9 countries, have now decided they're committed to doing that. The leader is Belgium, which has already adopted domestic legislation which largely mirrors the definition that we've adopted. The British government is totally opposed to it. Well, the current British government is totally opposed to it, but I'm very pleased to say that David Lammy has participated on a number of the Zoom and other talks, and he's personally very supportive of it. And it may well be, depending on what happens on the 4th of July, that we have a change of direction in relation to this issue. What happens next? Well, the Rome Statute has to be amended. That needs a certain number of states parties, of 124 states parties, to make a formal amendment proposal, and then they will start to negotiate. And here is my concern. My concern is that what will happen is what happened with genocide, is that the original definition taken by Lemkin, as it goes through the international legislative process, will change, and states that are extremely worried about finding themselves landed with allegations of ecocidal behavior will raise the bar. And the easiest way to raise the bar is to insert an intentionality element. But that isn't actually the only challenge with ecocide. It is pretty complex. In relation to genocide, war crimes, crimes against humanity, the standard applies anywhere in the world. It doesn't matter whether the act takes place in country X or country Z. Everyone has the same rights and the same standards are applicable. On ecocide, it's slightly more complex because we've had a lopsided situation of economic development, and the wealth disparities, as we know, are very, very great. And so in our working group, we accepted the idea that you could have an act in one country that crossed the threshold as ecocide, but in another country, it would not, depending upon its own history. And that's controversial, and it's complex, but it's necessary because in order to get this legislated at the International Criminal Court, you've got to have the global south, the developing world as it's sometimes called, on board. If they're not on board with it, it won't happen. And they won't be on board with it if they feel it's going to be used as a sort of neo-colonial effort to stymie their economic development and maintain the status quo. As a group, we were divided on whether to list certain things as acts of ecocide. And one half of the group wanted to list all sorts of things, and the other half of the group, myself included, did not want to have a list. And I didn't want a list. In the end, there is no list, and I'm pleased about that, because as with the identification of groups in the Genocide Convention, the moment you have a list with some in, by necessary implication, some are out. The moment you have a list, you have opponents in terms of certain activities. And could you imagine having a list that did not include climate change? But we're all ecocidaires, we are all contributing. So how do you create a threshold that says certain people are more responsible than others, which means they cross a line? So essentially, we are moving towards a definition of ecocide and a change. I was speaking to Robert McFarlane before we came in. I think, plainly as I've seen things over 30 years, there is a change taking place. There is an environmental consciousness. There is a move to a greater or some ecocentrism. I happen to think that's a really positive and important thing, but we should not minimize the complexities and challenges of what lies ahead in doing this in a world that is unequal. And in doing it, we should have regard to what happened in 1945 and the unintended consequences of a legislative moment with crimes against humanity and genocide that no one could fully predict. I would never criticize Lauterpacht and Lemkin for what they did in 1945. It was an extraordinary thing. They could have, each of them having lost their entire families and been prosecutors at Nuremberg, lain down in a corner and wept. They didn't. They were prosecutors, they developed ideas, they pushed their ideas, and I think that's a magnificent thing. But in the heat of the moment in 1945, no one thought through all of the consequences of dealing with the individual and the group in this particular way. And if we're going to move forward, as I think we should, on the environment and international criminality, we do need to think through what the consequences will be in an unequal world and in terms of the balance between the Anthropocene and the Ecocene. So these are really complex issues. For the younger people in the audience, it is a fantastically interesting moment, and it will be for your generation to take it forward, which is a big challenge but a very exciting challenge. Thank you very much.
Well, you can hear from the applause just how appreciated that was. Thank you so much. Without further ado, questions. Yeah, we've got one here. Very briefly, say your name if you want to, and...
Okay, thank you.
Yeah.
Henning Grossfuß-Kahn here from the Law Faculty. Thank you very much, Judith. I just have a question on those, thinking through those consequences if we were to go for ecocide. And let's assume we have this broader definition as you have explained. So who could be the perpetrators? You mentioned states, but you also kind of implied it might be individuals, perhaps even corporations. So what might that mean for multinational corporations who are seated in various jurisdictions that would probably increase their potential from being called in responsibility? And what about applying it to past conduct where there's continuous harm, where we have, under rules of state responsibility, arguments that intertemporality kind of doesn't apply or is limited if we have continuous harm. So climate change again being the main example.
Yeah, no, these are great questions. So our terms of reference were to come up with a proposal to amend the Statute of Rome, creating the International Criminal Court. So we were only focused on individual criminal responsibility. We did not have in our thinking the responsibility of states, and personally I don't think there's any point in adopting a convention on ecocide because I don't think states will sign it. Whereas the Rome Statute, that's a possibility. And the Rome Statute excludes corporate responsibility. There's some debate about it, but it's only individual criminal responsibility. I have to say, my own view on that is I'm not particularly sort of fetishistic about corporate responsibility, because the thing about corporations is you can't put a corporation in prison. They just get fined, they pay the fine, and they just move on. What really concentrates the mind is the prospect of a tap on the shoulder. And so it could be a chief executive officer, chief operating officer, chief financial officer, maybe a controlling shareholder. As an individual, you can capture the corporate involvement in those particular ways. And for me, that's good enough. I remember I once did a legal opinion in relation to crimes against humanity and certain individuals associated with smoking. And it was a real shock when a group of lawyers said, yeah, actually, if you knew when you were engaging in some of these activities that there was a real risk of catastrophic deleterious effects on human health, and you nevertheless continued to do what you did, given the consequences, widespread, systematic, etc., it is arguable that that is a crime against humanity. Same issues being debated right now in relation to climate change and corporate executives in the 70s and the 80s who, I haven't looked into it, but there are media reports, which of course I said to you, be cautious about, which suggest that there was knowledge and that people knew, even in the 70s and 80s, what the consequences were going to be. That is a basis for criminal liability in terms of the definition we came up with. But the issue that you've addressed, which is a hugely, hugely important one, is the temporal element. So genocide and crimes against humanity were only invented in 1945. So the basic position of states has been, well, okay, great, it doesn't apply to anything that happened before 1945, because you can't retroactively apply criminal law. But things are beginning to happen. For me, the single most interesting development, so for example, in relation to the killings of large numbers of Armenians, Turkey does not challenge that the Ottoman Empire is responsible for killing large numbers of Armenians. What it objects to is putting the label of genocide on it, because it says when that happened in 1915, the term genocide didn't exist, so you can't do that. But Germany,
there's so many people
I know,
to ask questions.
but just they need to know this, but Germany has 2 years ago recognized its treatment of the Herero in Southwest Africa, today Namibia, as a genocide, 1908. If you can characterize something that happened in 1908 as a genocide, why not 1808? Why not 1708? Why not aspects of colonialism? Why not aspects of enslavement? So that door is there, struggling to be opened or closed, depending on your perspective.
Fascinating. There's so many people want to ask. There was one here, and then I'll try and bring as many people as possible. I think there are people in the other room, so I'm going to quickly repeat the question, but please carry on.
Thank you very much, Philippe. Marcus Gehring, also from the Law Faculty. The prosecutor's office in the ICC has just issued or has applied for arrest warrants for individuals that have, in his view, committed war crimes or crimes under the Rome Statute. I was wondering whether you had a reflection on Karim Khan's application. And then second to that, you used the word wanton. And I remember the launching event where there was a lot of discussion about wanton and whether that implied some form of consciousness on the part of the perpetrator. Do you regret the word wanton?
I don't regret the word wanton. I think you have to have some element of recklessness in it, and that was the word that we best came up with. But I accept entirely some of the critiques as to the choice of the word. I haven't yet been able to come up with a better word, because one of the things that we did, knowing how the world is, you have to find a formulation that's been used in an existing international agreement, or there's zero chance. And wanton exists in the Geneva Conventions and the additional protocols, and that was basically why we chose it. But full flexibility and openness. In terms of the ICC prosecutor, I mean, you may have heard I did a short piece on the Today programme on this. They did ask, I mean, I'm slightly limited in what I can say because I'm currently counsel for Palestine in another case at the International Court of Justice on self-determination and territorial integrity in the occupied territories, which is not the South Africa genocide case. So I'm just careful what I say because I don't want to express views that may be different from Palestine's views, because then you get into all sorts of difficulties. So what I said was, I thought the evidentiary and legal reasoning of the prosecutor, which is backed by a report written by 6 individuals of the highest quality, is unimpeachable. It is totally spot on. The 6, you know some of them, they are just world-class, and they have got it exactly right. I raised the question, however, on the Today programme of timing. Was it the best moment to do it? I'm divided about this. Was it the right moment to do it? And the reason that I said that was that the prosecutor had previously, a year previously, issued an arrest warrant, requested and got an arrest warrant in relation to Vladimir Putin. And the effect of that was to buttress support for Putin in Russia and bring people from the middle. And I think we're seeing that both on the Israeli and the Hamas side. So tactically, it raises a really serious question if that's a wise thing to do. Actually, I'm very critical of the indictment of Putin, not because I don't think that there isn't evidence to have done that, but because I think the decision to publicly indict Putin was motivated by a desire to head off the creation of a special criminal tribunal for the crime of aggression, which the prosecutor, my former student, is opposed to, not on an issue of principle, but because he doesn't want another court, I think, taking the glory away from the International Criminal Court, its turf. And I think what he has done is indicted Putin to say, look, we don't need the crime of aggression, I can deal with Putin, with war crimes and the deportation of children. I think that was a mistake, I think if it happened, it should have been done secretly, as they did with Milosevic and others in the 1990s. But of course, the downside of doing it secretly is you can't parade yourself around the world as this glorious person who's doing all these incredible things. So there are issues.
Every question is going to lead to an extraordinary response. So, Karina, and then one up there. You first. Go first, yeah.
Thank you. So my name is Saite. I'm a fellow in economics here at Humanity College. I'm just thinking, before your talk, I thought ICJ could clear things up very well. And now I've learned the ideas of intent, and it seems like the Israeli spokesperson knows this very well. They have all the perfect ways to respond. We're not awful, we're looking into this, and it was a mistake. And it cannot easily prove there's any intent to commit genocide to start with. But I'm interested, what would be the legal framework in place, should be in place during a war and conflict like this? Because I like numbers. If I look at the amount of bomb that's being dropped in Gaza, it's more than Dresden, it's more than Blitz combined. And even that cannot change the war conduct, then what should change?
No, I mean, these are really important questions about the function of this legal order. I mean, it's plainly imperfect. But the question I think one has to ask oneself is it worse than what existed before 1945? Okay? And I have difficulty saying it's better to have nothing. We're not going to have a perfect international legal order. So the best is the enemy of the good. What I tell my students to try to keep them feeling positive and optimistic is it's a very, very long game. I mean, you've probably heard this story before, but we were together at St. Catherine's in the 1980s. A wonderful colleague at St. Catherine's, John Baker, professor of English legal history. And as a 25-year-old, I'd be thrilled if occasionally he'd invite me for lunch and ask me what I was doing. And I would tell him what I was doing in international law, and he'd sort of look at me and say, oh, yes, we had a problem like that in English law in 1472, and it took 295 years to sort it out. And he's right. And that's the way to think about it. It's a work in progress. It's not perfect. We know that. Just to be crystal clear, what happened on the 7th of October is a crime under international law. War crime, crime against humanity. Some people say it has a genocidal aspect to it. What's happening in Gaza is criminal, no question. The ICC prosecutor, backed by this report, has issued a request for arrest warrants. Now, this is what is very interesting. And again, the media, who are sort of not as attentive as they should be, what does he want arrest warrants for? War crimes and crimes against humanity, not genocide. So you've got two courts in The Hague. They're two different courts. Yeah. And the judges at the ICJ are going to be looking over their shoulder and saying, ooh, they've thrown genocide at us and they want us to deal with genocide, but that bloke over there is not doing genocide. He's doing war crimes and crimes against humanity. Frankly, very sensibly, because they are plainly war crimes taking place, and almost certainly there are crimes against humanity taking place. It's undoubtedly criminal. The battleground is the label you put on it. And you've all understood that. Yeah.
Karina, and this will have to be our last question, I'm afraid, but there are drinks and you can talk over to Karina.
So this is a question about the metaphorical but also legal homology that you're making between genocide and ecocide. So I was reminded very strongly by the first part of your talk of Hannah Arendt saying of the 18th century that it's ironic that at the very moment that the rights of man identify an individual who enjoys these rights by virtue of being an individual, that man that has rights, is subsumed under the collective. So you move from the rights of man to we the people. So I'm wondering whether there's a kind of similar quandary that exists with using the term ecocide, which risks the bifurcation of responsibility. So we are nature and nature is us. But if we subsume everything under this idea of an ecology which is not us, then we risk personalising that kind of legal responsibility. But if we make it too anthropocentric, then we're just being romantic, right? We're just projecting our own kind of selfish concerns onto nature and behaving that way.
What an interesting question.
It's a fantastic question.
Yeah.
And there's obviously just a lot of thinking and talking to be done. One thing I just want to share with you that is really important in this academic context, we're in a university environment, ideas really matter. All of the things that I'm talking about have their origins in the work of scholars and thinkers who then sow them and they then get picked up. And in a sense, we should be celebrating your question because it is centering this conversation on what goes on in a great university like this and other great universities. They are exactly the questions. But let me, so just to respond in the simplest way in the form of an anecdote. So we gave then definitions, you can find it on the web. What does severe mean? Severe means damage, which involves very serious adverse changes, disruption or harm to any element of the environment, comma, including grave impacts on human life or natural, cultural or economic resources. We couldn't get away from the Anthropocene. And in addressing these kinds of issues, we kept coming back to it. Wanton means, in our definition, done in some haste, with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. So what are social and economic benefits? It's us, again. So, and this has been criticized by some purists as a nod to ecocentrism. But when you're actually drafting in the context of having to come up with text which some legal advisor or minister in a government is going to say, yeah, I can run with that, if you exclude this kind of formulation, it's dead. So the challenge is exactly like Lemkin's. He was devastated with the final definition of genocide in the Genocide Convention. They took the elements of what he had, but they changed it. But in the end, he said, you know what? It's better like this than nothing at all. And that's the debate and the question to be had. Is it better for there to be nothing at all, or to have an incremental move in a particular direction? And I think reasonable people will disagree on that classic revolutionary dilemma, but it's the beating heart of the issue, and it's we all know it's going to be discussed a lot in the next few years. This will happen. I've got no question that this will happen. It's just an issue of when it will happen and precisely the formulation. And your questions go to the heart of those issues.
Thank you. I mean, we could have had, to hold your clapping for a moment, we could have had so many questions from the floor, but I think what we've had is an incredibly rich discussion. I mean, classically for Cambridge, both philosophical, intellectual, and indeed legal. And I think what you bring, Philippe, and what I most admire about you is your ability both to be an incredibly precise, academic, focused lawyer and one of the best storytellers I think I've ever come across. And that, the way you have woven your personal and family story into this lecture tonight, I think is one of the reasons why you've had this spellbound audience. I think you've also taught us a thing or two, and a number of light bulbs going off during the lecture as you explained the difference between these four different kinds of genocide, crimes against humanity, war crimes, and the crime of aggression. I think you literally saw us all understand that for the first time. But I think even more interesting and important to me is the sort of cultural associations of those words. And as you say, with genocide occupying this unique place in international law and becoming this word that captures in a way that is both helpful and unhelpful, frankly, the kind of emotional and other overlays which make the challenge of implementation really, really hard. But you've also taught us to read extremely carefully what is said about judgments. And I think the kind of sweeping generalisations in the press it's a reminder to us all that we can so easily misunderstand. But I think this emergent concept of ecocide is so important, and what we've been exploring in the last few minutes around how society comes to terms with both the responsibilities and the obligations, I think is a story that's still evolving, and clearly learning the lessons from genocide, whether those lessons will be learned or not is probably not something most of us can have something to do with, but actually to understand what's going on has been really revelatory. And while the world is, under such pressure environmentally, the sooner we get some clarification there, frankly, the better. But finally, Philippe, you told us at the beginning that the environment has been the beating heart of your career. That is so evident. We admire you so much for what you've done, what you will continue to do. And thank you so much for coming tonight. It's been a splendid lecture. Thank you.
Thank you.